The witnesses today. We'll begin our first 5-minute round. And I'm going to start by just exploring how we can respect existing copyrighted works, copyright protections, while continuing to safely develop and advance AI technologies. If we run out of time, we'll do a second round. My hunch is there's at least that much interest. Mr. Brooks, if I might just start with you. Generative AI models like those your company creates are trained in no small part on vast quantities of copyrighted content, on data from copyrighted content. Do copyright owners know if their works have been used to train Stability's models? Is Stability paying rights holders for that use? Why not, if not? And how would doing so impact your business and your business model?
Thank you, Senator. So to the first question, models like Stable Diffusion are trained on open data sets or curated subsets of those data sets. So Stable Diffusion, for example, takes a 5 billion image data set. We filter that for content, bias, quality, and then we use a 2 billion image subset to train a model like Stable Diffusion. Because it's open, you can go to a website. You can type in the URL of an image. You can type in a name. You can see if that work has appeared in the training data set. And then we're working with partners to take those opt-out requests and, as I say, to incorporate them into our own training and development processes. So we do think open data sets are important. They're one part of how we are able to inspect AI for fairness and bias and safety. And so that's, I think, to the first part.
So if I heard you right, if an artist takes the initiative to search your training set, they might be able to identify that a copyrighted work was used and then submit an opt-out request, and you are in the process of facilitating that use. But to my second question, do you pay any of the rights holders?
As I say, Senator, this is 2 billion images, a large amount of content. A lot of it, all kinds of content. Right? Take language models, for example. It's not just books. It's snippets of text from all over the internet. As I say, to make that workable, we believe, that it is important to have that diversity, to have that scale. That's how we make these models safe. It's how we make them effective. And so we collect it, as I say, from online data. What I will say is that the data sets that we use, like that 5 billion image data set I mentioned, they respect protocols like robots.txt. So robots.txt is a digital standard that basically says, I want my website to be available for ancillary purposes such as search engine indexing. And so the data set that was compiled respected that robots.txt signal. And then on top of that, as I say, we have the opt-out facility that we've implemented.
Thank you, Mr. Rao. It's my understanding that Adobe is taking a distinctly different approach. Your generative AI model, Firefly, was only trained on licensed data. Were there any downsides economically to that decision? Is your model less robust, or has it had any impact on its performance? And how would you compare these two approaches in terms of the incorporation of opt-out and licensed?
Yeah, thank you for the question. So as I mentioned in the opening remarks, Adobe Firefly, our generative AI tool, was trained on our stock photography collection, which are all licensed assets with the contributors. And that's actually the only data set used in the version that you can use on Adobe Firefly on the web. We think about the quality of this, and when we think about the quality to your question, we had to put a lot of image science behind that to make sure it was up to the level we require, because we didn't have the most expensive version of that data set. So we had to put more computer science behind it to make it have the higher quality we needed. As we go forward, we're looking at whether or not there are other areas where we need to supplement that data set. And for those, we refer to as openly licensed content, or places where the copyright has expired. Openly licensed to us means images that come from the rights holders who have licensed it without restriction. So very similar to what we're talking about in the licensed content. This is also what we call commercially safe. My
sense, Mr. Brooks, is Stability is trying to honor something like 160 million opt-out requests in training your next model. Mr. Rao, Mr. Brooks, this will be my last question, then I'll turn to Senator Tillis. Should Congress be working to ensure that creatives can opt out of having their works used to train AI models? How would you best do that, briefly?
So we have this technology we refer to as content credentials in my opening remarks, and what that does, it's a metadata that goes along with any content. So if you're in Photoshop right now, you could say, I want content credentials to be associated with this image. As part of that, you can choose to say, I want it not to be trained on a do not train tag. That gets associated with the image and it goes wherever the content goes. So we do think the technology is there and available, and we're talking to other companies, including Stability, about this as an approach to honor that tag, so people, when they're crawling it, can see the tag and choose not to train upon it.
Should we require that?
And I do think that there's an opportunity for Congress to mandate the carrying of a tag like that, a credential like that, wherever the content goes. Right now, it's a voluntary decision to choose to do that.
Should we require that?
There's some very interesting precedent internationally for this. The European Union has introduced certain kinds of text and data mining exceptions, and part of that is to say that you can use this for commercial, non-commercial purposes. There is an opt-out requirement, but the opt-out has to be machine readable, as I say, as a matter of practicality when you're dealing with trillions of words of content, for example, or billions of images in this case. The machine readability is important, and that's where these tags become an important part of how to implement it in practice.
We'll keep exploring this further. Senator Tillis.
Thank you, Chair. I'm going to have Senator Blackburn go, and then I'll follow Senator Hirono.
Excellent. Thank you, Senator Tillis. And Mr. Chairman, thank you for the hearing today. It's so appropriate that we have this. I'm from Tennessee. We have thousands of artists and songwriters and musicians, and we have actors and actresses. We have authors and publishers. And everywhere I go, people are talking about the impact of AI, to the positive or the negative. You know, you look at healthcare, you look at logistics, you look at autos, you look at entertainment, and there are pros and cons. But the one point of agreement is you got to do something about this so that it is going to be fair and it's going to be level. Mr. Harleston, I want to come to you right off the bat because you mentioned the NIL issue, which I think is an imperative for artists to be able to own that. And you also mentioned the right of publicity laws. And of course, those are state level laws. And as you rightly said, we don't have a federally preemptive right to publicity law. And I think the dust up, a lot of people came to realize this over Drake and the Weeknd and Hard on the Sleeve. And this is something that does have to be addressed. So for the record, give us about 30 seconds, and then you guys see your capable team behind you. You can submit something longer in writing if you'd like on the reason state level publicity laws are not enough.
In 30 seconds. State level right of publicity laws are inconsistent from state to state. A federal right of publicity that really elevates right of publicity to an intellectual property is critically important to protect.
Okay, I'm going to help you out with this. A federally preemptive right to publicity law would provide more of that constitutional guarantee to her works that Ms. Ortiz has mentioned.
Absolutely.
So, all right. And
we will follow up with you, Senator.
yeah, excellent. I think something in writing would be very helpful there. Now, I think it was very appropriate that you had Spotify and Apple Music take down Hard on My Sleeve. Important to do. And talk about the role that the streaming platforms should play. Should they be the arbiter when it comes to dealing with this generative AI content?
The streaming platforms, we acknowledge that they're in a challenging position, but certainly in some instances when it's clear that the content that's been submitted to them for distribution.
So a knowing and willingness standard would be nice.
That would be very nice. Yes, ma'am.
Okay. I'm helping you out there.
You're doing
Thanks
great.
for being here. Okay, Professor Zag, want to come to you. This spring, the Supreme Court issued what I thought was a very appropriate decision in Warhol versus Goldsmith. And I was very pleased to see them come down on the side of artists. I filed an amicus brief in this case arguing for strong fair use protections for creators. Now, we've been through this thing in the music industry where fair use became a fairly useful way to steal my property. And artists don't want to go through that again. Right, Ms. Ortiz? It didn't work the way it was supposed to. And I would like for you to talk for a moment. Should AI, unlicensed AI, ingestion of copyrighted works be considered fair use when the output of AI replaces or competes with the human-generated work? Now, Ms. Ortiz has laid this out fairly well in her comments, and the Supreme Court has sided with the artist in Warhol versus Goldsmith. But this fair use standard comes into play every time we talk about our fabulous creative community and keeping them compensated. So the floor is yours.
Senator Blackburn, commercial replacement should not be the test. The test should be exactly what the Supreme Court said in the Andy Warhol case. The question is this significantly transformative? What that means in relation to training AI models is, does the output of the model bear too much resemblance to the inputs? Now, that's a different question to, is it competing with the inputs? Could it be used as a commercial substitute? If you look at some of the old cases on reverse engineering software, companies were allowed to crack open software, find the secret keys to interoperability, and build new competing products that did not contain any copyrightable expression. And the court said that that was fair use. So I think on current law, the answer is no. Potential substitution in terms of a competing product is not the test. The test is, are you taking an inappropriate amount of an artist's original expression?
Well, my time has expired. Thank you for that. We just don't want it to become a fairly useful way to steal an artist's product. Thank you, Mr. Chairman.
Thank you, Senator Blackburn, and thank you for the passionate engagement you've always brought to these issues on behalf of the creative community. Senator Hirono.
Thank you, Mr. Chairman. Mr. Harleston, whenever the idea of negotiating licenses is raised, people express concerns about how complex it would be and how AI platform developers could never possibly negotiate with all rights holders. But in the music context, at least, you have a lot of experience negotiating rights. Could you tell us a little bit about your industry's history of negotiating rights with digital music services and lessons that history could teach us for whether rights negotiations would be possible with AI platforms?
Thank you, Senator. As you referenced, we've had a long history with the transition of our business from a physical business to a digital business, and having to encounter digital platforms that were very quickly adapted by consumers and had lots of our content on there. Mm-hmm. What we found was ingenuity does play a role. It's not easy, but we were able to identify or find ways to identify our copyrights, to work out licensing schemes that allowed the platforms to be able to carry and distribute the music and in a commercial environment that was positive for them, while at the same time allowing the artists to be properly compensated. And this is, in the music side, we have two sets of rights, which makes it even more complicated. But we've done great work over the years to develop systems that allow identifying not only the sound recording but also the underlying composition. So it could be done. But what it needs, what we would need is we need help to make sure that everyone understands that there are rights that are affected and that the activity that is happening now is violative. And once they understand that what they're doing is violative, that brings them to the table so we can negotiate a deal.
I note that in your testimony you said that consent is the key. So is your position that every artist's work, before it can be used to train AI models, that the company that's wanting to use that information has got to get the consent of the originator?
In a very short answer, yes.
And you think that we are able to do this knowing that that these platforms incorporate billions and billions of information to train their AI models?
Understanding that, but it absolutely could be done as the digital platforms that exist today, the licensed platforms ingest millions and millions of songs every week. So it's not a problem in that respect. There's metadata we could license. We could absolutely do that, but there has to be an initiative on the side of the companies to reach out.
So, Mr. Ortiz, Mr. Brooks, rather, sorry. What I heard you say in response to the chairman's question is that for all of the data that you input into your model, you do not get the consent of the artist or originator. Is that correct, Mr. Brooks?
So Senator, we believe that, yes, if that image data is out on the internet and robots.txt says it can be subject to aggregated data collection, and if it's not subject to an opt-out request in our upcoming models, then certainly we will use those images, potentially use those images if it passes our filters.
So basically, you don't pay for the data that you put into your to train your models.
For the base, the kind of initial training or teaching of these models with those billions of images, there is no arrangement in place.
So you have Ms. Ortiz who says that is wrong. Is that correct, Ms. Ortiz?
100%, Senator.
So do you know if, well, I think you mentioned that your work has been used to train AI models, and you have gotten not 1 cent for that use.
I have never been asked. I have never been credited. I have never been compensated 1 penny. And that's for the use of almost the entirety of my work, both personal and commercial, Senator.
So if you were to allow your works to be used to train, do you think that you would negotiate, if there was a law that required compensation, then that compensation negotiation should be left to you and entities such as Mr. Brooks's?
Personally, I love what I do, so I wouldn't outsource it to an AI, but that's not a choice for me to make, and it's all about that. It's about being able to have that choice, and artists don't have that right now.
Okay. Thank you.
Thank you, Senator.
Thank you, Mr. Chair. I was actually inspired by one of the opening statements, so I went in and generated a cat driving a 1960 Corvette with a surfboard in it, and produced that picture. It actually gave me 4 options. This one I found the most interesting. But it raised a question that I wanted to ask you, Mr. Brooks. If an artist looked at that and said, that is in part developed by that 60s Corvette in South Beach, how does that artist then go about saying, I'm trying to get an understanding of your current opt-out policy? And one of the issues that we've had here, and not completely related, but we have a notice and take down or notice and stay down discussion in the past around creative works. So I was just trying to understand, and I think it's going to be a lengthy answer, and then if I talk to a creative, it's going to be a lengthy answer. But for the record, it would be very helpful to me for your specific platform to understand how that opt-out process works. I think I heard right that you could embed within the works certain things that already create an opt-out or that work shouldn't be used. But I want to drill down. We don't have time to do that now. In a twist of irony, I was wondering if any of the witnesses would suggest any creative works by other governmental bodies that we should steal and use as a baseline. In other words, what good policy seems to be being discussed or passed, and what particularly problematic at either end of the spectrum, because I'm sympathetic to the issues at both ends of the spectrum on this argument. So maybe we start with you, Professor. Are you aware of any Western democracy states? I'm not particularly interested in what China's doing, because whatever they agree to, they're going to rip off anyway. But any best practices that we should look out there, or bad practices or trends that we should avoid or be concerned with as we move forward?
I think that the European Union's approach, where they have different rules for commercial and non-commercial use, and opt-outs have to be respected for commercial uses of the text mining in Article 4 of the DSM, has something to recommend it. By the same token, I would note opt-outs do not apply to researchers working at proper research institutions in the EU, nor do contractual overrides, which is a position that I can't see Congress adopting, but it's certainly something to look at. That's really it.
Anyone else briefly could add what? Ms. Ortiz, I should also add, I've seen all your works, and it's been since 11 o'clock last night that I was talking about Guardians of the Galaxy with my colleagues as we were coming back from Vilnius.
It was a really fun project to work on, Senator, so thank you. So what the artist community have suggested is that models be built starting from scratch via public domain only works. That's work that belongs to everyone. Any expansion upon that to be done via licensing. And there's a couple of reasons for this. Current opt-out measures are inefficient. For starters, machine learning models, once they are trained on data, they cannot forget. And unlearning procedures are just dead on the water right now. And this is not according to me. I'm an artist. I have no idea on this. This is according to machine learning experts in the field. Secondly, safety filters, like, for example, prompt, filters are so easily bypassed by users. So unfortunately, when companies say, hey, opt out, there's no real way to do that. But even further, what happens if someone doesn't know how to write or robot.txt? Like, how does a person who may not know the language, may not know the internet, may not even know that their work is in there, recognize that, they need to opt out? This is why my community in particular has suggested over and over, opt-in should be the key in order to base the foundations of consent, credit, and compensation.
And Mr. Brooks, I can understand the challenges with opt-in versus opt-out in terms of the task that you would have ahead of you. But what's your view of the concerns that creatives have expressed in this light, and the current opt-out process that you all have in place, or procedures, which I'd like to get information for the record?
No, thank you, Ranking Member. Look, I'll say at the start that we do need to think through what the future of the digital economy looks like. What do incentives look like? How do we make these technologies a win-win for everyone involved? These are very early days from our perspective. We don't have all the answers, but we are working to think through what that looks like.
I'm going to stick around for a second round, so we'll get a little bit deeper into that, but I want to defer to my colleague.